Hi, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about judicial independence. Cases that should have gone to the Supreme Court of Canada, but didn't. Eliana Marengo is a judge in Quebec. She heard a case involving a woman who came to court wearing a hijab. Because of certain legislation in force in Quebec at the time, the woman was not permitted to be heard by the judge. The judge ordered her to either adjourn her hearing or consult with a lawyer. When the woman refused to do so, the hearing was adjourned and no further date was set. In between the time period when the hearing was adjourned and when the case was next ultimately scheduled to come before the court, 38 complaints were filed against this judge with the Judicial Council. These complaints allege that the judge had acted improperly in enforcing that section of the Quebec legislation and refusing to hear the woman's case. The judge applied to dismiss the complaint on the basis of the fact that judicial independence prevented her decision applying the law and giving reasons for applying it from being reviewed by the Judicial Council. That was dismissed, the Court of Appeal dismissed it, and she sought leave to the Supreme Court of Canada. This case raises really important issues about the principle of judicial independence. While judges are bound by the law and bound to apply the law, whether they apply the law and how they apply the law is supposed to be listed in their reasons for giving judgment on any particular issue. If a person has an issue with a judge's reasons, the appropriate course of action is to take it to an appellate level court. Filing a complaint because a law being applied by a judge is unconstitutional is not the appropriate mechanism to deal with the constitutionality of a law and a judge's duty to apply that law, regardless of whether the judge agrees with it or not. This case would have been important for the Supreme Court of Canada to hear to clarify the importance of judicial independence even in the face of laws that clearly affront the Charter and that clearly violate people's human rights. In the circumstances, by referring the matter to the Judicial Council and having the matter heard by them, it gives the appearance that there is merit to claims against judges for simply applying the law, even though the law itself may be wrong. And it opens the door for more judges to be complained against and more judges to have to answer for their conduct, rather than litigants taking their issues to the appropriate levels of court and filing the appropriate constitutional challenges. The Supreme Court of Canada had the opportunity to clarify long-standing principles of judicial independence and ensure that the matter would be heard in the fair and appropriate manner, and unfortunately they didn't take this opportunity, which means that we may see more cases of judges being reported and complained about for simply applying a law, even though the law itself might not be something very tolerable.
You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't.
Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative puts these videos together. Please like, subscribe, and share with your friends, and tune in next week for another episode.